This is the case of Communication Materials and Design Incorporated versus the Court of Appeals. The facts show that petitioner CMDI and ASPAC are both domestic corporations. Respondents ITEC Incorporated and ITEC International Incorporated are corporations duly organized and existing under the laws of the state of Alabama, United States of America. There's no dispute that ITEC is a foreign corporation not licensed to do business in the Philippines. ITEC entered into a contract with petitioner ASPAC referred to as representative agreement. Pursuant to the contract, ITEC engaged ASPAC as its exclusive representative in the Philippines for the sale of ITEC's products, and in consideration of which, ASPAC was paid a stipulated commission. 1 year into the second term of the parties' representative agreement, ITEC decided to terminate the same because petitioner allegedly violated its contractual commitment as stipulated in their agreements. ITEC charges the petitioners of using knowledge and information of respondents' product specifications to develop their own line of equipment and product support which are similar if not identical to ITEC's own, and offering them to ITEC's former customer, which is PLDT. Thus, ITEC filed a complaint with the RTC. The defendants, or the petitioners in this case, filed a motion to dismiss. After conducting hearings on the prayer for preliminary injunction, the trial court issued its order denying the motion to dismiss and directing the issuance of a writ of preliminary injunction on the same day, which the CA later affirmed. Hence the petition. It is the petitioner's submission that private respondents are foreign corporations actually doing business in the Philippines without the requisite authority and license from the Board of Investments and the Securities and Exchange Commission, and thus disqualified from instituting the present action in the courts. The issue is whether or not the Philippine courts may assume jurisdiction over a case involving a foreign corporation not licensed to engage business in the Philippines. The Supreme Court ruled in the affirmative. Petitioners' insistence on the dismissal of the action due to the application or non-application of the private international law rule of forum non-convenience defies well-settled rules of fair play. According to petitioner, the Philippine court has no venue to apply its discretion whether to give cognizance or not to the present action because it has not acquired jurisdiction over the person of the plaintiff in the case, the latter allegedly having no personality to sue before the Philippine courts. This argument is misplaced because the court has already acquired jurisdiction over the plaintiff in the suit by virtue of its filing the original complaint. And as already observed, petitioner is not at liberty to question plaintiff's standing to sue, having already acceded to the same by virtue of its entry into the representative agreement. A foreign corporation doing business in the Philippines, although not authorized to do so like respondent, may sue in Philippine courts against a Philippine citizen or entity who had contracted with and benefited by said corporation. To put it in another way, a party is stopped to challenge the personality of a corporation after having acknowledged the same by entering into a contract with it. And the doctrine of estoppel to deny corporate existence applies to a foreign as well as to domestic corporations. One who has dealt with a corporation of foreign origin as a corporate entity is stopped to deny its corporate existence and capacity. The principle will be applied to prevent the person contracting with a foreign corporation from later taking advantage of its non-compliance with the statutes, chiefly in cases where such person has received the benefits of the contract. By entering into the representative agreement with ITEC, petitioner is charged with knowledge that ITEC was not licensed to engage in business activities in the country, and is thus stopped from raising in defense such incapacity of ITEC having chosen to ignore or presumptively take advantage of the same. Taking all this into consideration, it is clear that the court has acquired jurisdiction. Now it is for the Philippine court, based on the facts of the case, whether to give due course to the suit or dismiss it, on the principle of forum non-convenience. Hence, the Philippine court may refuse to assume jurisdiction in spite of its having acquired jurisdiction, and conversely, the court may assume jurisdiction over the case if it chooses to do so, provided the following requisites are met. First, that the Philippine court is one to which the parties may conveniently resort to. Second, that the Philippine court is in a position to make an intelligent decision as to the law and the facts. Third, that the Philippine court has or is likely to have the power to enforce its decision. The aforesaid requirements having been met, and in view of the court's disposition to give due course to the questioned action, the matter of the present forum not being the most convenient as a ground for the suit's dismissal,